Okay, the next session is Lawfare. I'm very pleased to introduce two gentlemen that will speak to us. Robert Gouveia is the host of Watching the Watchers Live. He's a criminal defense attorney as well. And Watching the Watchers Live is a daily legal and political live stream focused on police, prosecutors, and politicians. And Robert spoke to us during our Get Trump conference and did an excellent job, and he was supportive of our marketing efforts, which we greatly appreciate. We also have Mr. Joseph Sweeney, who is the author of the recently released book called Dangerous Injustice. Joseph Sweeney served in the CIA Office of General Counsel for 25 years in support of a broad spectrum of intelligence operations all over the world. So we're very pleased to have Joseph Sweeney and Robert Gouveia to take them off of news, or maybe take yourselves off news. Joseph is off of mute. Robert, there you go. So, Robert, would you like to start?
Sure, happy to. Yeah, thank you, David. Can you hear me loud and clear coming in?
Yes.
Great. It's good to see everybody. Thanks for having me. And David, thanks for putting this together. I think that this type of conversation is very important, and I'm happy to be a part of it. And I want to say hello to some friends and some people in the chat who are joining us. It's great to see everybody. Good to see Mr. Sweeney again and some other friends. Today, we are talking about the New York prosecution, Alvin Bragg. And this was one of the four that has resulted in a verdict, actually 34 guilty verdicts. And so we'll talk about it and zoom in on what actually happened, because there are some outstanding appeals. And then there was a big development where Trump is not going to be sentenced before the election. And that was a major, major loss for their side. And I think the reason that they are delaying the sentencing is because their case is just a disaster. It's wrecked. The Supreme Court came back down and issued an immunity decision that we'll talk about. I'm sure it's going to come up a bunch throughout the day today. But I want to explain what evidence came out in this Bragg prosecution and why it's so bad, why it really wrecks their case, and why I think the whole thing is ultimately going to go away. So let's introduce ourselves to some of the main figures who are a part of this. I do have some slides, as you can see. When we first were on this case and covering it on our channel, we were talking about it as the Michael Cohen, Stormy Daniels, Alvin Bragg prosecution. These are the three people. Remember, Stormy Daniels was the porn star, Michael Cohen was Trump's ex-lawyer, and Alvin Bragg's the guy in the middle. They were the main people that we were focused on at the outset. But now it's actually kind of changed. Now we're paying attention to these people. This is Madeleine Westerhout, and this is Hope Hicks. These were two people who worked for President Trump, and a bunch of their testimony came out in the trial, and this is immune evidence that should have never been brought out. And so what ultimately happened, let's kind of work backwards, is we're starting this. This is the one of the four criminal prosecutions. The other that we have that Mr. Sweeney's going to talk about is the Florida case, but we also have the Georgia case and the January 6th case, which is still ongoing right now in the DC circuit. But this is the only one that resulted in verdicts. And so you'll see they say these are all guilty. The charges were falsifying business records in the first degree, and it's times 34 of them. So you see we got 3 verdict sheets here with all of the guilty verdicts for the president. Now, just to quickly recap what these charges are made up of, and to show you why they're such a joke, is you can see in the indictment itself, there were 34 counts falsifying business records in the first degree. And what they ultimately did is they charged Trump for different pieces of paper. So Michael Cohen, Trump's ex-lawyer, would send him an invoice for some legal services, right? The invoice was one charge. Then somebody would put an entry into a ledger, right? Like a business ledger, basically a spreadsheet, which would be another charge. And then they would cut a check from the Trump organization, and the check stub would be considered another charge, right? So they did this over multiple months, and these were payments from Trump to Michael Cohen, the lawyer. They said Trump basically falsified what those were for and literally wrote on the check that they were for something that they were not, right? In the ledger, that these were for certain expenses that they were not supposed to be categorized as. And so here is a signature from Trump. This is one of the checks that he signed. It was $35,000. Other checks that were at issue here, because these are all falsifying business records. Okay, so what is the record? It's the checks and the other entries. And you'll notice that this check was drafted and sent out on the October 18th of 2017. And so Trump was the president at that time in 2017, which means that theoretically this could be arguably immune because he was the president, and the Supreme Court said that immunity applies to the presidency. Just we have to ask ourselves how specifically. So breaking it down, this is how it worked, right? Cohen would send an invoice, somebody would enter it into a ledger, then Trump would cut a check, then the check would go to Cohen, he would cash it. They would say that these are just improperly kind of campaign expenses, not legal expenses, which is how they were classified as. Trump said they were legal expenses to Cohen. They said, no, these were campaign cover-up expenses because it was covering up payments to Stormy Daniels. So long story short, these were the payments. 7 were for $35,000. All said and done, it was about $180,000. No, total was $420,000 total that was paid over to Cohen. And that was the basis of the charges upon which Trump was ultimately found guilty. Now, there's a question that comes up, legally speaking, about how Trump was able to be charged here. And so I just like to mention this because it's kind of a common question that comes up on our channel, is about the statute of limitations. How was Trump able to be charged in this crime for 2017 offenses? A couple different reasons for that have been argued. One is that he was president for a period of time, so that stopped the statute of limitations. And then the other was COVID. There were some COVID extensions. And then the last kind of sneakiest bit of all this was that they turned this into a felony. Okay, so ordinarily, this is a misdemeanor. So when we go to New York law and we look at falsifying business records in the second degree, we're going to see that that is a misdemeanor offense. It's a class A misdemeanor. In this case, they elevated it, they escalated it into a felony by turning it from the second degree into the first degree. And they did it using this very sneaky little provision here. So it goes from second into the first degree. In order to be guilty of first degree falsifying a business record, you have to have the intent to commit another crime or to aid or conceal the commission thereof. So they went and they found this, and they said that Trump commits first degree because he also is intending to commit some other crime. And so if you're a criminal defense attorney, we're all asking ourselves, well, what is that other crime? And does there need to be unanimity on the other crime? What are the elements of the other crime that he needs to intend to do? And do they just need to prove intent, or does there need to be something else there, something more? Well, the judge said, no, it's only intent. Okay, so they don't even actually have to prove what the other crime was, essentially, as we're going to see. As long as you have intent to do something else bad, and the jurors could even disagree on what that other thing was, that is sufficient. And so when we actually went into the jury instructions and saw what the jury instructions look like, this is what happened at the end of the trial. This is what the jurors saw. They read this: for the crime of falsifying business records in the first degree, the intent to defraud must include an intent to commit another crime, right? So wide open. You could drive a truck through this. Any other crime? Are you kidding? Okay, what crime? Let's see. Now, under the law, the government, Alvin Bragg, the prosecutor, must prove an intent to commit another crime. And specifically, these were the jury instructions. They need not prove that the other crime was in fact committed, so that it was actually done, that it was aided in, that you did anything to further that crime, or that it was even concealed, right? So we're not looking for other facts or other actions. It's just intent. So it's just in the person's mind. Did Trump have the intent in his brain to go commit some other crime? And you can see how easy that's going to be for prosecutors to try to prove. They just find a bunch of bad people that don't like Trump and just ascribe him ulterior motive and negative intent. So that's one part of the jury instructions. And I just clipped some of the highlights out. But if we zoom way out on this and we ask ourselves, okay, it says he has to commit another crime. So what is that other crime? It's a big, broad offense that's a New York election violation. And so I know we're getting into the weeds here a little bit, but I think this is important. This section provides that so they're saying Trump committed falsifying business records in the first degree because he was going to commit some other crime. What other crime? This crime, New York election law crime. It says that if you intended to commit or conceal any other crime, that's a violation, and that two or more persons are conspiring to promote or to prevent. There's a conspiracy. That's the statute. Now, in this statute, right, you see this right here? This is how the judge got so sneaky. And this is confusing. I'm sharing this with you because this is what the jurors are going through, right? They're trying to figure all these rules out. How do we determine whether Trump is innocent or guilty or not? So the judge is layering this in. It's a misdemeanor offense that they've turned into a felony by alleging another crime. The other crime is a New York election crime, and there's an unlawful means component to this. Well, what are the unlawful means by which Trump intended to commit this other crime? It's whatever the jurors wanted, right? This was another part of the jury instructions. So although they wrote, you must conclude as a jury, right? Because we think of juries as being unanimous. They should not have disagreements in there. You must conclude unanimously that Trump conspired to promote or to prevent the election of any person by unlawful means. But you don't need to be unanimous as to what those unlawful means are. So Trump, as long as he intended to commit some other crime, which is an election law, however he tried to do that counts. And so we joked about this on our channel. We said all the time, this was a pick a card, any card, right? Whatever you want, it's going to be fine. Jurors could just pick one, and that's good enough. In determining whether Trump conspired to promote or to violate the election, they could pick any one of these three, and the jurors did not have to be unanimous on this, right? So they could just pick whatever they want. They could say Trump violated federal election campaign laws, which is something that the Department of Justice already investigated and declined to prosecute on. So the jurors can substitute their judgment for a prosecutor's judgment and pick a federal election crime as the unlawful means for a state crime. Use federal law for a state crime. And jurors may have, we don't know. We also have, they could have picked the falsification of other business records, right? So Trump committed some other falsification of business record, and this was intending to cover that up. Or it was a violation of some other tax laws. So really, anything that the jurors wanted. It was a multiple choice prosecution. And by the jury instructions themselves, they don't even have to be unanimous in this. So they can just pick what satiates them and call it a day. And so it was very long and complicated and convoluted, but there was no way out essentially for Trump because they could have just picked whatever they wanted, and they did. And then when you combine that with the demographics of New York, this is how Manhattan, which is what Alvin Bragg, this is his jurisdiction, this is how they voted in 2020. You can see it's 87% in favor of Joe. So 87-12 for Trump. It's not a good, favorable jurisdiction. We're not talking about fair and impartial juries in any way, shape, or form. And so, again, these are the verdicts, guilty. And the next question, of course, after a guilty verdict is sentencing. So every time somebody gets convicted of a penalty, of a crime, or sentenced, generally what happens is you have different reports that are generated. The defense will create a sentencing memorandum and submit that to the judge. The prosecutor will submit their recommendation. The court usually has a third party that does a probation report or some independent analysis for the court. And then we come back and we have a sentencing. And at the sentencing, that's when the judge declares whether somebody goes to prison or what the penalty is. So right now, we do not have that. And so from my perspective, and there are people on the other side who take a different perspective, but Trump has not been convicted of anything yet. And you can say it's kind of a term of art. So people will say, well, he was found guilty or he was convicted by the jury. But until he's sentenced, until this record is closed and until this criminal conviction hits the federal databases, this case is still open from my perspective. And he has not been convicted of anything quite yet. He's pretty dang close, but not yet. And what happened in the middle of all of this, okay, so we were going through all of those charges. We had a full trial happen. The verdict came down. and we were waiting for sentencing to occur. And sentencing was scheduled not too long ago. So this is from the judge's sentencing order. This is a new order that just came out. And it says, by letter dated August 14th, Trump requests an adjournment of his sentencing, right? It was already scheduled. The sentencing was scheduled for September 18th. And the left was thrilled about this because September 18th is before the election. And they were waiting. Finally, Trump's going to get justice. And we were having a debate about this. Are they going to incarcerate him or not? Are they actually going to imprison him? And we were debating that at length. But turns out they're not going to have to do that. And why? Well, the Supreme Court decision came back down, and this is Judge Merchan, and it really threw him for a rub. And now he's going to have to figure out what to do with this case because he screwed up big time. And we'll come back on that and zoom in on the immunity stuff. But he wrote this. Trump says, this was a funny one. This guy absolutely hates Trump. Says he attempts to bolster his application by repeating a litany of perceived and unsubstantiated grievances, blah, 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 blah. But nonetheless, to assist the court, we are going to grant Trump's adjournment, right? So he goes here, Trump's a moron, everything he says is wrong, he's bad, I'm right, whatever. But we're going to grant Trump his request and grant the continuance. And so the postponement happened, and it got continued until after the election. Oh my goodness. And this was a big fun day on our channel, but we had the two dates got updated. So they're going to Trump and his defense team after the guilty verdicts came down. They filed a motion to set aside the jury verdict. And they, in the motion and in the filings, they're saying immunity and other bases, including due process problems, witness evidence problems. I mean, the whole case was a disaster. But the judge said, I'm going to determine whether I can even keep this verdict, and we're going to set a new date on that for November 12th, of course, just a few days after the election. And then he scheduled sentencing for November 26th, way after the election, which means Trump is not going into custody before the election, which was a real actual possibility. I mean, we actually were contemplating that happening because these people are maniacs and they would have liked nothing more. So it was a huge victory. It was a huge deviation, and it was different than everything else that we've seen because they've been racing to get Trump. In fact, this case was scheduled for a trial after the January 6th trial, which was the Judge Chutkan case. But what happened was Judge Chutkan stopped the case and Merchan didn't. We'll come back to that in a quick minute. But some updates on the appeal process. You see, Trump is also appealing the verdicts. He submitted this. This is a notice of appeal. He's trying to take this case from the state level court, which is where we're at right now with Alvin Bragg. He's appealing it to the Southern District of New York. And it's a removal proceeding, basically saying that he is a federal officer, the president, and that the federal court should have jurisdiction over this matter to take it away from Judge Merchan at the lower level court. And this entire time, Trump has been gagged on this case from Judge Merchan. And so he also appealed the gag order. Now that the trial is over, you can see, and the Court of Appeals of New York denied those as well. So Trump's gag continues. The motion for leave to appeal this has all been denied. The appeal was denied. They say there's no constitutional question involving Trump's free speech. So those are the updates on the Bragg case. Now, the thing that really caused a rub in this whole prosecution is this decision, the immunity decision. Trump versus United States came down from the Supreme Court. And what it told us, very briefly, is that when we talk about presidential immunity, we have three buckets of immunity. We've got conduct that goes into this box, which is going to be conduct that is not immune at all. This is stuff that is not presidential acts, can't even be argued to be presidential acts. It's just not immune. Then we have stuff that is presumptively immune. And then we have stuff that is absolutely immune. So if you're in the presidency and it's articulated, it's explicit, you have the right to do this thing, they can't turn around and prosecute you for doing the thing. It's absolute immunity, and SCOTUS has talked about that. There's also presumptive immunity. And if you're even, they talked about it, like even within the outer line, like if you're very close to the line between presumptive and non-presumptive, not immune and presumptively immune, we're going to defer and just push it this direction into being presumptively immune. And we're talking about conduct. So can the president talk to this person, or can the president sign that document, or can he travel to this location, or whatever the president does? Supreme Court came out and created really strong protections for the presidency, because that's how our country has been functioning for 234 years until they started to prosecute Trump. Functionally, we had no presidents prosecuted for anything. And it's not like Trump was the first president to do things that could be theoretically prosecuted. So if this is the structure that the Supreme Court gave us, the problem here is that Judge Merchan in the Bragg prosecution, he disregarded both of these categories completely, okay? Just said, this doesn't even count. There is no immune stuff. So anything that is in these boxes is really in this box. And so the trial was all considered not immune, but that's not what the Supreme Court said. Now, the proper thing that he could have done would have been to have paused the case, just like Judge Chutkan did in the January 6th case, and allowed the appeals to work their way out in the Supreme Court. But he didn't do that. He kept this case going. Trial came forward, and a bunch of evidence that should be immune was introduced. And so let me show you that briefly. You see, this is Madeleine Westerhout. She testified at the trial. She was a secretary to Trump. She was a director of Oval Office operations. She was fired for some comments, but she's reconciled with Trump, and she was considered Trump's gatekeeper. Here's some other evidence, right? There's a picture of her in the Oval Office, and she's explaining how Trump literally dictated his tweets to her, standing in the Oval Office. Okay, here's another scene with Madeleine Westerhout, Trump, and Mike Pence, and they're all standing there in the Oval Office, talking about business. Now, the problem with this is that Madeleine Westerhout was brought in. They asked her a bunch of questions. This is a scene she left. She was kind of talking about Ivanka Trump. She wrote a book about it. Says, my dream job at the White House, how I lost it, and what I learned, right? So she had a kind of a bad exit, but she was very involved. And this is some testimony from her trial. Question from the defense. So you were working in the White House, Madeleine, when the Stormy Daniels story came out? Yeah. Trump was upset? Yes. He was concerned that his family would see it. Objection sustained. The answer is stricken from the judge. Any redirect, right? So they're talking about this stuff. And this also came up with the prosecution. Prosecutor says, okay, Madeleine, you work in the Oval Office. How does someone call the president? Well, they might call me or the Situation Room. If it was John Smith off the street, there would be screeners. Did Trump use a computer or have an email account? No, not to my knowledge. Would he pay attention to detail? Yes, he signed things himself with a Sharpie. Did you use social media? Yeah, we use Twitter, now X. Did anyone else have access? Dan Gouveia. And so there was a bunch of testimony about the inner operations of the White House. Same thing with Hope Hicks. She was the Trump campaign press secretary, became the comms director, also now was working over at Fox, was an aide to Jared Kushner, and she probably even gave Trump COVID. That's how close she was to the guy. So call logs also show she was talking with Michael Cohen. And Trump and Ms. Hicks were working together very close. In fact, when Hope Hicks was leaving, New York Times reported that Trump is losing a limb with the departure of Hope Hicks. Well, they dragged her in. They asked specifically about her work with Trump in the Oval Office. Where did you work from, said the prosecutor. Just outside the Oval. There were 2 desks. There was a vestibule. There was a mini fridge. There was a coffee machine. And so who was in the second desk? Well, Madeleine Westerhout, right? All this, in my argument, in my opinion, is immune conversation. Trump's allowed to do this stuff without government prosecutors encroaching and infringing upon the executive branch. The Supreme Court created immunity to stop this specifically. When Stormy Daniels resurfaced, they asked Hope Hicks, what happened next? Well, President Trump told me that Michael had paid about a false allegation with his own money, right? So actually Trump is saying that actually happened that way. But she was she was working for the president. And they said, well, is that consistent with what you know of Michael Cohen? Like, would he pay for that himself? No, he was not a charitable person, so no. Right, so they're bringing in Trump's employees. All of that stuff is immune. And so when we zoom back out on this and we ask ourselves, what buckets included immune, or where should the evidence go in these various buckets? it's clear that some of the evidence was at least in the presumptively immune bucket or in the immune bucket. And so once this is briefed and presented to Judge Mercan, I think he's going to have a hard time holding the sentencing on that date. And if he does, I'm sure going to see Trump appealing this. And so the lawfare in New York continues, but there's a nice victory for Trump because that immunity decision really came back down. They were on path to have him sentenced, and in our thesis, maybe even ask for jail, or at some level ask for home detention or something like that, so that they could keep him off the campaign trail. But the immunity decision came back down. Mercan is recognizing that he has to change his strategy a bit. And so that's good news for Trump. Doesn't mean the lawfare will stop there, but at least it's limited for the time being in New York, and it's going to get us passed through the election.
Okay, excellent presentation. Maybe just a couple very quick questions before we turn it over to Joe. Why didn't Judge Mercan recuse himself? His daughter is making a lot of money as a political activist, and she's very antagonistic to Donald Trump. So there's that issue. And then my understanding is that these judges are supposed to be selected by lottery. And I think Judge Mercan or another one of these judges in lawfare cases has been chosen supposedly by lottery multiple times, which statistically seems almost impossible.
Yeah, it's a great question. And a lot of people are raising their eyebrows at that. Yeah, Mercan was on a number of Trump cases. I think, and I don't remember specifically, but he was on definitely, I think, a Weisselberg case with it, which was a Trump CFO, and maybe a Bannon case. I think he drew a Bannon case. So he's drawn some Trump-focused cases, and speculating on what happened behind the court scenes is, just going to be speculation, but it's probably what we all think it is. It's an anti-Trump judge just happened, is catching some very nice cases that they want to send his way. However that's happening, I don't know, but it is happening. He's gotten a lot of cases. Now, as to your other question about recusal, yeah, he's got some very interesting things. He donated to Joe Biden. He donated, I think, 3 times, $10, $10, and $15. One of those donations was to a Stop Republicans organization, which was an anti-Trump organization specifically, and the other 2 were to Joe Biden. It was only like $35 or so, but it's kind of a spite donation. And his daughter literally worked or is a part owner or is somehow related business-wise with an organization called Authentic Campaigns. And they literally worked for Kamala Harris and Joe Biden, and they ran ads for Democrats. They're a Democrat advertising campaign operation. And so they were even creating posts and email newsletters that were selling and raising funds off of the case. Trump is just being arraigned in New York. Chip in now for Adam Schiff's Facebook fundraiser or something that was being run by Authentic Campaigns. The daughter, she's a partner there, and it's the judge's daughter. So when they filed to recuse the judge, he got an ethics opinion from another court there, another ethics commission there in New York, and they told him, you're fine as long as it's separate and it can be impartial. And so he has stayed on the case. Trump has asked to remove him and to recuse him, I think, 3 separate times, and he's just staying on in spite of all of that clear conflict.
Okay, thank you very much. Excellent presentation. Let's go to your co-presenter now. Let's turn it over to Joseph Sweeney. I think you'll talk to us about classified documents cases.
Thanks, David.
Thanks for having me, David. I appreciate it. Let me start by telling the participants a little bit more about my background because it's relevant to my book. I was in the CIA General Counsel for 25 years, as David mentioned, but I had an unusual career because 12 of those years were in the litigation division of the CIA General Counsel's office, up to including being the chief of that division. And because I was there for so long, I developed expertise in cases involving the mishandling of classified information and the theft of classified information. The kind of traditional spy cases you would see in the movies, right? Where we've caught someone stealing secrets to sell them to a foreign adversary. So I've worked on that whole spectrum of cases to include a subset, which was the cases where senior government officials were investigated or prosecuted for mishandling classified information. Now, there's only 4 of those cases in U.S. history, and I worked on 3 of them. So what I'll do for you is I'll just briefly touch on them because I don't have much time, and then I'll talk about Biden's and Trump's cases, because the precedents are important because they set the tone for how DOJ and the FBI historically handled those types of cases where senior government officials were caught mishandling classified. So there were 4 cases. One of them, the first one, was John Deutsch. He was the director of Central Intelligence under President Clinton. Deutsch had over 300 classified documents, up to top secret, some very sensitive, on his home computer that was not protected, unsecured in the government parlance, and which was hooked up to the internet. And when he got caught, he tried to destroy the evidence. So Deutsch's case was investigated. I worked on the case with the independent counsel at the time, and Deutsch was signed a plea agreement for 1 classified document that was at the secret level. The next case was Sandy Berger, who people might recall was President Clinton's national security advisor. Berger got caught stealing top secret presidential records from the National Archives by sticking them down his pants and in his socks, bringing them home and destroying them. He destroyed evidence. He lied to the FBI numerous times. He tried to blame the archives for the loss of the documents. And eventually he came clean and confessed. Berger was also prosecuted for, 1 misdemeanor. He ended up getting a probation and a fine, as did Deutsch, although Deutsch was later pardoned by Clinton. So you can see these 2 cases set a tone where senior government officials were treated very leniently with the gentlest of investigations and prosecutions. And neither of those cases involved subpoenas, no search warrants, no grand juries. The third case was another director at the CIA. That was David Petraeus. That was a little more recently. Petraeus got caught with 8 notebooks of highly classified information in his home, and he had also provided them to his biographer, Paula Broadwell, who he was having an affair with. There's many interesting human interest stories. That's probably the best one. And so Petraeus also was permitted to have a plea agreement to 1 misdemeanor, fine, probation, no jail time. Very lenient. And the last president was the Hillary Clinton case, which everyone remembers. I participated in the classification review of her emails. I'm one of the few people to have read the fabled Clinton emails, and I just want to tell all the participants, I am not suicidal, so anything ever happens to me, you know where to look. So in that case, in Clinton's conduct was completely egregious. It was not just grossly negligent, it was purposeful. She set up a server in her home for all of her government email when she was Secretary of State. And someone at that level has to know that those emails will contain classified information, and they did. What was reported publicly was that there were a little over 100, but I can tell you, having participated in the classification review, it was probably in the thousands. And I go into detail on all of these cases in my book. So Clinton, she didn't even get charged with anything, right? And again, no subpoenas, no search warrants. Her lawyers were permitted to run the searches on her servers. The FBI never seized them. They never even looked at them. They literally permitted her private lawyers to run searches for evidence in a criminal investigation. I was not aware of any other case until Biden's case. So Clinton, FBI Director Comey gave a press conference saying that her conduct was extremely careless, but not grossly negligent, because gross negligence is the standard under the law. I personally think those 2 descriptions are synonymous. And I think any reasonable person would. But as a result of that press conference from Comey, Clinton was not charged with anything, despite fairly egregious conduct. So those are the four precedents. The commonalities in those precedents: one, all high-level Democrats, and two, all treated very leniently by the Department of Justice, where they either got just a fine and a probation, only charged with one misdemeanor, despite in all the cases a gross negligence in the handling of classified information and even willful conduct, and also obstruction of justice from lying to the FBI and DOJ. So all treated very leniently, okay? So now fast forward to Trump's case. And I was retired for about a year when the FBI raided Mar-a-Lago. And I was fascinated by the case because I had worked on the precedents. And I'm also a student of American history, always have been. And I was just flabbergasted that in my country, one political administration could raid the home of the former president of the opposing party with 30 FBI agents armed and authorized to use deadly force, right? I just could not believe that something like that could occur in my country, and that half the country was not only okay with it, but behind it, and thought it was positive. So I started researching the case. And what I found with every stone that I unturned was incredible deviousness by the FBI and DOJ to turn Trump's conduct into something that was unlawful. Because I can tell you, Trump broke no laws. I'll just go, when I compare Trump's case to Biden's case, I break it down into three categories. One is the conduct at issue. The other one is how the investigations were handled. And then lastly, the charging decisions. And in all three of those categories, there are stark disparities in how the two cases were handled. And I mean exactly 180-degree opposite, even though it's the same FBI and the same DOJ handling the cases. So in Trump's case, the documents left the White House that went to Mar-a-Lago. Well, Trump didn't pack the boxes himself. There's not even an allegation in the indictment that Trump knew what was in the boxes. The special counsel got around that by just saying Trump caused everything. It was a very unique form of causation, right? Just because Trump was responsible for things going to his house, he had caused classified documents to be packed into boxes when there's no allegation that he even knew what was in them. Okay, and then also in the indictment, they broke it down into 32 felony charges, one for each classified document that they chose to charge. Well, as I said, I've worked on a spectrum of Espionage Act prosecutions, from real spies, people who are stealing our secrets, to just mishandling and gross negligence. In none of those cases did we break down and charge individual documents. Not even for foreign spies. There would be one charge under the Espionage Act, and then we would select which documents or pieces of information to support that one charge. But they went so overboard for a former president to break the charges down into 32 separate felonies. I can tell you that's never been done before. So while I'm investigating the FBI raid and analyzing the FBI affidavit, which is full of mistakes, and I go through all of them in my book, I also, at that time, it comes out on the public record that Biden had classified information. Now, that information was withheld from the public for over 2 months. And this is one of the basic disparities. All the facts in Trump's case were put on the public record immediately in great detail, where with Biden's case, originally covered up for over 2 months after the documents were originally found in the Penn Biden Center and in Biden's garage, kept off the public record. Finally, it got to a point over 2 months later where Biden's malfeasance had grown to such an extent because they kept finding more classified documents in his possession that the administration could not contain it anymore, and they leaked the story to the press. Now, let's talk about Biden's conduct. You know, again, with Trump, the boxes were sent to Mar-a-Lago. There's not even an allegation that Trump knew what was in the boxes. With Biden's case, there weren't just boxes in his house. The documents were all over Biden's house. The first level den, the third level den, the foyer. There was a grocery bag with classified documents outside of his bedroom. There was a stack of classified documents in the foyer. There were classified documents in his personal library, and they were in filing cabinets, and they were, in some cases, in files where the files had Biden's own handwriting on the file. And so there is no doubt that Biden knew that he had classified information, that he had it all over his house, and he had been stealing it for 50 years, a time span. Those documents that Biden had spanned, I mean, this is unbelievable, right? It spanned half a century. And he had over 100 in the house alone, many of which were top secret, highly classified, and again, all over the house. So when you're just looking at the conduct, you can see right away, factually, the great disparity between Biden's case and Trump's case. And you would think that as a result of that disparity, Biden would have been charged more aggressively than Trump. We all know the outcome there. Biden not charged at all. Trump, 40 felony count indictment, 32 of which just go to documents. Let me talk a little bit about the investigation, because that's when the true disparity really comes out. In Biden's case, it was investigated more like Hillary Clinton's case. Everything was done voluntarily. No subpoenas, no search warrants, no grand jury. So all done voluntarily. And again, like Clinton's case, with Biden, the FBI and DOJ, while they had an open criminal investigation, permitted Biden's attorneys to search Biden's homes first. So first, they didn't search at all, and they let Biden's private attorneys search the homes. Now, when have you ever heard of the FBI or DOJ permitting a potential defendant's attorneys to rummage through a crime scene, which they did? Those attorneys did not have security clearances, which means technically they should not have even had access to classified information. Classified information had already been found in the house. There was a likelihood that more of it would be found, and yet the FBI and DOJ actually facilitated additional crimes by permitting people who did not have clearances to have access to classified information, because they say they didn't read the documents, and I would take them at their word for that, but they shouldn't have even been able to hold those documents because that gave them access, and that's unlawful. So that's just part of the investigation, compare it to Trump's. In Trump's case, the FBI and DOJ moved expeditiously to legal compulsion, subpoenas, search warrants, grand jury testimony. They even went so far as to take Trump's private attorneys and haul them into the grand jury and force them to divulge attorney-client communications with their client, Donald Trump. Now, they first got an 87-page opinion from Judge Beryl Howell in the District of Columbia to permit them to do that. They claimed there was something called the crime fraud exception that permitted them to, pierce this attorney-client privilege of communications. I analyzed that opinion in great depth in my book, and as you can imagine, I'm not a big fan of the opinion. And by the way, that Judge Beryl Howell, she was the same judge who was on the Mueller investigation. I refer to her as a frequent engineer on the Get Trump train. She's also the judge who permitted Congress to get access to the grand jury transcripts, which is normally not done, for some of the impeachment hoaxes. So with Trump's case, they immediately moved to legal compulsion. They forced Trump's attorneys into the grand jury. Now think about this. Biden's attorneys had been permitted to rummage through the crime scenes and search for classified documents. And the special counsel admitted in his final report that he would have really liked to talk to Biden's attorneys because he was curious as to how they knew to start looking for classified documents in the home in the first place. But in that case, in Biden's case, he said, gee, I would have liked to have asked them those questions, but I couldn't out of respect because they were attorney-client privilege communications. So again, it's another great example of how the exact opposite approach was taken between, Biden's case and Trump's case. So there are many, many other anomalies in the investigation. I'm just throwing out a few of them. So let's look at the charging decisions. Now, in Biden's case, the special counsel and DOJ came up with what I call, a whole deck of get out of jail free cards, right? They came up with many, many ridiculous reasons on why Biden could not be charged. I'll just touch on a few of them. The one that everybody heard, because it got the most publicity, was that even though Biden had been caught admitting to possessing classified information that in his home, that he probably forgot about it because he was too senile, his memory. And this is very interesting for me because what happened during the investigation was Biden had been working with a ghostwriter. This is after his presidency, and because he wanted to write a book. And so the ghostwriter was recording some of the conversations so he could have them, to assist him in writing the book. And in one of the conversations that was recorded, and this was February of 2017, you can hear Biden say, as he's coming up the stairs from the basement, I just found all the classified stuff downstairs. Now, this was his private home while he was a private citizen. He's all done with his time in the government at the time. So it's that recording from February 2017 that the special counsel said, given his memory was so bad, even back then, we don't think juries would put any weight to that. That's 3 years before Biden became the president. The special counsel said his memory was that bad. And then the special counsel took it a step further and he said, and another thing is, this is just an 8-word utterance. We don't, we don't think a jury would put much weight on an 8-word utterance. I couldn't believe it. I mean, it's basically a taped confession. And could you imagine a prosecutor in a murder case having a recording of the defendant that says, I just killed him? Well, that's just 4 words. Can you imagine a prosecutor not using that or dismissing it because it was too succinct of an admission that a jury might not put much weight in? That is the extent to which DOJ went to not prosecute Biden. Now, you look at Trump's case, it's just the opposite. They twisted laws, twisted them well past the breaking point to be able to say that Trump's conduct was unlawful. Trump was president when those documents went to Mar-a-Lago. And there is evidence right in the indictment that the people working for Trump had talked to Trump, and he was referring to all of those things as his papers. And under the Presidential Records Act, he's allowed to determine that some records are his private papers and others are presidential documents. He's allowed to make that determination. That determination was made while he was president. And yeah, there might have been some mistakes, but he was in the process of returning documents when they found things that should have gone to the archives. And so despite that, they still charged Trump, even though there's evidence right in their indictment that he thought all of those things were his personal papers. And they have no evidence, not even in the indictment do they allege that Trump knew what was in the boxes. And I also thought it was interesting that, in the indictment and other things they filed in the case, we've all seen the photos of the boxes, right, that they included. Boxes stacked to the ceiling, boxes around toilets, boxes up on the stage. Why would they have those photos? They found about a little over 100 documents in the raid that would have fit in one box. So why are we looking at photos of 50 boxes? Because a picture's worth 1,000 words. And you won't see pictures like that in Biden's case. You know, one of the things Biden did was he donated about 2,000 boxes of documents to the University of Delaware. The FBI only sampled them. They sampled about 250, and they found classified documents in them. Now, you've never seen photos of Biden's 2,000 boxes, and you know what? You're never gonna. So that's just kind of skimming the top of the great disparities that are in both, you know, the conduct, how the investigations were handled, and how the charging decisions were made. I encourage folks to read my book if you are interested in getting more detail. I didn't write this book for fame or fortune. I would have been happy staying in the shadows my whole life. But as I started researching, I realized I'm one of the only people in the world who has the expertise to see how great the deviancy was, right? Because none of this was an accident. It was thoughtful. They twisted laws purposefully, and the level of depravity that went into bending over backwards to get Trump while bending over backwards to protect Biden is shocking. And you can see it on the surface, but you'll never see the extent unless you have someone with experience telling you about it. I'll tell you, last week I was lucky enough to be on national television. I was on the Jesse Waters show. And as a result of that, my book sales spiked. Amazon responded by removing my book from the marketplace. It literally said, temporarily out of stock for 24 hours. My book has no stock. My book is published on demand. It's POD. You order it, it gets printed, and it gets sent to you. There's no stock, but they labeled it temporarily out of stock. And then I just found out today that Amazon and Meta are refusing advertising of my book on their platforms. And in order for me to advertise it on other platforms, it would cost 10 times as much, which is prohibitive for me. So if you're interested, please get the book, take a look. I've got a contact form on my website. Thanks to Robert. I was on Robert's show. And Robert, you got a great following. I have received, Robert, hundreds of emails from the people who listen to your show. And they ask good questions, and I'm answering every single one because I'm just excited to have people actually know this stuff and then ask good questions about it. You know, having said all that, let me know if there's any questions.
Yes, before we go into questions, again, the name of the book is Dangerous Injustice. Maybe tell us your website where people can order directly.
Sure, it's sweeneyjb.com. And what I've done is I'm adding extra stuff to the website along the themes of the book. And in the upcoming weeks, you know, I've got years of research, and I'm going to put it all on the website because a lot of the questions I get from people are, they just can't believe some of the stuff they're reading. But my research is sound. Everything is documented. If I'm criticizing the Biden-Harris administration and the Democratic Party, and I do, and I just don't look at these cases, I go all the way back to 2016 and the unlawful targeting of the Trump campaign through intelligence collection methods, which I'm very familiar with. I back it up. And so I'm eventually going to get in the upcoming weeks, I'm going to get all my research so that people can, when they're interested in particular topics, they can dig down and see more facts.
Great. Okay, we'll take a question from Michael Goldstein. Go ahead, Michael.
Hi, Mr. Sweeney. It's a pleasure listening to you. I'm a 30-year veteran of the intelligence community and a 30-year Navy veteran, retired. My question, and I'm also an attorney. So my question is, how can Trump's attorneys in this case raise, and at what point can they raise the equal protection argument? Obviously, they were treated completely in a disparate manner. How can that be used?
Yeah, from what I've seen, and by the way, thank you for your service. From what I've seen, um, I haven't seen an equal protection argument, and I don't even know. Robert would know better than me whether whether that would fly in the criminal context. What you see in the criminal context is selective prosecution, right? Prosecutorial abuse, and they have raised those, and the judges have shot them down, and not let them get traction, because a lot of them are making allegations that judges can dismiss as just being political, which is unfortunate. But they haven't gotten any traction along those lines that I have. I don't know if Robert has seen any traction along those lines, but I have not.
Take Robert off mute.
There we go. Okay. No, I have not seen anything exactly like that. We did cover in the classified documents case the selective and the vindictive prosecution. So Trump's team has filed that. But like you said, Judge Cannon didn't believe that. I mean, we don't really know. There were a bunch of other filings in the classified documents case that were in the vein of motion to dismiss. But I think some of the thought process was maybe she was not addressing those because she was saving it for a dismissal based on the appointment, right? So if she didn't have that in her back pocket, maybe she would have invested more into the other motions to dismiss. But because she had the appointment issue, maybe she just saved it and dismissed everything on that basis. But there was a selective and vindictive prosecution filing, and I think she denied that. I think we read that on the channel.
Yeah, and you've just refreshed my recollection. She dismissed many things of that nature, but not completely. What she said was they were premature. So she wanted the record to develop more, before and then the parties are, they can refile. So it was not dismissed with prejudice. It was just dismissed for the time being. But another thing that strikes me, and I should have mentioned this, Trump was the president, and of course you can appreciate this, having your experience. All classified information is done under presidential executive order, and the president represents the executive power in pure form. So Trump can do whatever he wants with classified information. So could Biden. Biden could, this weekend, take a box of it to Rehoboth Beach and hand it out to sunbathers. He will have broken no law. Now that's disturbing, but that's the law, and that's true. And yet, when Biden was stealing classified information, he was doing it as a senator and as a vice president at a time when he was under the authority of the executive order, just like every other employee below the president. And that, there hasn't been enough focus on that, I think. And in the indictment and in the FBI raid warrant, it is unbelievable the extent to which they bend over backwards to kind of ignore what I'm telling you, right? A reader of that affidavit, either of them, either the indictment or the FBI raid affidavit, you would never know what I just told you, because what they do is they have one sentence in there that says, information is classified pursuant to executive order, and they just make it sound like it's a mere ministerial act with no ramifications. And then they go into the litany of rules, all of which in terms of storage, handling, access. And there are many, many, many rules, as there need to be, to safeguard classified information. But what they never tell the reader, what they never tell the court, is that none of those rules apply to the president. Those are all rules that the president has made to people below him, but he doesn't have to obey any of those rules. There was some reporting on like declassification, for instance, and I saw this in the news. It's one of the things that motivated me to write the book, was all the disinformation that was out there. There was, Trump couldn't have declassified unless he did a memo, and the documents were stamped and so forth. That's all wrong. It's completely wrong. Trump could, or Biden now, could declassify information by waving a wand over it while yelling "Spectro declassiarmus," right? That's all. He can do it any way he wants. He could literally quaff 3 martinis and write it on a cocktail napkin with a swizzle stick, right? It's the president. He can do whatever he wants. Those below him need to obey the rules. But you wouldn't know any of this to read the FBI raid affidavit or the indictment.
Thank
Yeah.
you.
Yeah, I think
Thank
we all
you.
have to read Dangerous Injustice. Just a couple quick questions. I've heard that the FBI spread the documents on the floor at Mar-a-Lago. You talked about doing the photo op with all the boxes. My understanding, they spread the documents on the floor and maybe even sometimes mark some of them as classified.
Sure. What they did was they brought with them those red, glossy, sexy cover sheets. And then what they did was they laid the documents out, put the cover sheets on top of them, then photographed it, then put those photographs on the public record. In my book, I call that it's the law enforcement version of a Victoria's Secret fashion show. So now a judge could call that evidence tampering, but at a minimum, it's propaganda. And again, a picture's worth 1,000 words. And I've worked in the area of propaganda, right? Because one of the things the CIA does is covert action. Covert influence is part of covert action. And I used to train CIA officers on covert action and covert influence. And I talk about this in the book. And I give specific examples of propaganda coming from the media or the FBI. Not that there's much of a difference these days. They're kind of hand in glove. But I give specific examples of it, and that's one of them. And I'm glad you brought that up.
Biden's attorneys that were able to take the first look at his house and classified documents, was there any effort to make sure that they were at least American citizens?
No, there was nothing like that. And you know what? That's another good question, because if they're not citizens, they're not even allowed to have a clearance under the executive order. So it would be an even further risk to national security. But no, there was nothing of that nature. They weren't vetted in any way, shape, or form, and they had carte blanche to rummage through the crime scenes.
So with your book being taken down essentially from Amazon, I don't think their algorithms are that sophisticated. I think if there's a surge, I've published a lot of books on Amazon as well. I would imagine if there's a surge of demand for a book, if anything, they would highlight it, promote it, give it better positioning. During the last presidential election, I believe there was a FBI agent, Elvis Chan, who was the intermediary with social media, Twitter and Facebook. He would tell them to take stuff down or maybe put stuff up. Do you think that there was somebody in the FBI or CISA or CIA that has a channel to Amazon that may have told them to remove your book?
I can only speculate, but my speculation would be that it was someone in the Democratic Party, someone who has pull with Amazon and didn't like the message in my book. Obviously what we've seen with the weaponization of DOJ and the FBI, it could have absolutely been one of them. I'll never know. And I can tell you no explanation was ever given to me. All of a sudden, I started complaining, and then about a day later, the book was then available again, but it went down at a peak time. And my publishers told me they hadn't seen anything like that happen before. And normally, because one, there's no stock of the book, it's published on demand. And if for some reason they were running behind, what they would do is extend the delivery time or put it on back order, but not outright remove it from the market, which is what happened. But it's now back. So anyone who wants to read it, please read it.
Probably better to go to your website though.
Well, my website links back to Amazon.
But
what I've done is I've ordered extra books myself, so that if this happens again, people can indeed come directly to me and I will mail them books.
So my understanding is the way the classified documents got started is the National Archive basically just entrapped Trump. They just sent pallets of documents to Mar-a-Lago. Is that right?
So it's actually more devious than that. And even though my book is about the weaponization of DOJ and the FBI, they also weaponized, well, really, they've weaponized the entire executive branch, but they absolutely weaponized the National Archives. And I go into great detail in my book, because there were FOIA releases of the emails of some of the higher ranking people at the National Archives. Now, they released this in a big tranche with hundreds of pages, and you had to pick through all of them. But I used to do FOIA work for the government. I'm the guy who had the redacting pen in his hand. I'm a veteran of many FOIA litigations. I know how to pick through a FOIA release. And I went through hundreds and hundreds of pages, and I found documents where NARA was structuring what they were doing. They were in league with the White House. They were getting directions from the White House. And I'm not making spurious allegations. These are not histrionics. I back it all up with the actual emails. I state who they were to, when they were sent, what they contained, and it shows NARA scheming with the Biden administration to cover up Biden's malfeasance when the documents were first found. And then they bent over backwards. They violated their own regs. They changed their regs just to go after Trump and to help the White House. It's all in the book in great detail. And you know, one other thing is, and nobody's talking about this anymore, when Trump's attorneys first found the documents in the Penn Biden Center, they sent 9 boxes to their law firm in Boston before they even notified the White House of what they had found. Well, those 9 boxes, I call them the 9 mystery boxes, because then there's emails with NARA. And what they were doing, and it's clear, very clear, they were avoiding putting specifics in their emails. But NARA, from whatever they were finding out in phone conversations, got very concerned. And all of a sudden, it went within one day, the NARA emails start saying things like, we have to change our approach. We're going to send 2 people to get the boxes tomorrow in Boston. Please make sure they're locked and in a secure space where no one else can have access to them. And my friend will know this. You only send 2 people to get documents when they're top secret. That's a rule for couriers. And to courier top secret information outside of the DC area, you need 2 people. And they sent 2 people. It's a near certainty in my mind that these 9 boxes contained classified documents. And not only that, they must have all been vice presidential records, because all 9 boxes went to the archives, right? Now, here's the real nefarious part. 4 months after the archives got those 9 boxes of documents, Congress asked them, hey, what's in the boxes? Have you guys looked in the boxes? NARA said, we haven't examined the boxes yet. And that's the last we've heard of the 9 mystery boxes. There's no accounting on the public record for them. And NARA, the lack of curiosity, they were intent on getting those 9 boxes immediately. And they claim that once they got them, they didn't even bother looking inside. The lack of curiosity is unbelievable, because when Trump returned 15 boxes to the archives, it was all over the news. NARA made a press release. They even talked about the contents of the 15 boxes. They reviewed them in 3 weeks. Again, a huge, inexplicable disparity, unless the reason is the weaponization of the National Archives against Trump and to protect Biden.
So the last question, if Trump is reelected and takes office, can the deep state be cleaned out? Can this cancer be excised from the government, or is it just too embedded for anybody to choose?
I get that question a lot. And my answer is, it can probably never be completely eradicated. And the swamp cannot be completely drained. And I give numerous examples. You know, some people say the swamp doesn't exist. I give numerous examples in my book of how all the connections work on certain issues and how they all lead to high-level Democratic people who've been active in the swamp for years. So that's the bad news. The bad news is it's unrealistic to expect that you could completely eradicate it. However, that doesn't mean that we shouldn't try. And I think a lot could be achieved. I think you'd be kidding yourself to think that you're going to completely eradicate it, but it's something that's worth doing, and there could be quite a bit of progress.
Okay, well, great. So that brings us to the end of the Lawfare session. So I'd like to thank again Robert Gouveia, host of Watching the Watchers, and Joseph Sweeney, served in the CIA as chief counsel for many years and is the author of Dangerous Injustice, fascinating book that all of you should try to read. So, gentlemen, thank you.